AI is no longer a concept of the future. It's here powering everything from supply chain optimization to customer service, predictive analytics, and even the products you build. It's a very powerful tool bringing many benefits to our society, our companies, and us as individuals. But with great power comes great responsibility. And the EU recognizes that this tool is so powerful that at a certain moment in time, people could get harmed by it. That's why the European Union is creating these rules called the EU AI Act. The primary goal is to harness the power of artificial intelligence while at the same time stimulating innovation with it. It's about finding a balance of stimulating innovation with the crucial need to safeguard people's well being and rights. It sets certain boundaries specifically designed to protect people's health, people's safety, especially in products, and people's fundamental rights. So, how could this affect your business directly? Let's break it down. First, what exactly is an AI system under this Act? The Act provides a very broad definition. It doesn't just cover fancy machine learning or deep learning, it covers a whole wide variety of algorithms from the most simple linear regressions all the way up to that very complex AIs that are mimicking humans, including large language models and image generators. This broad definition is actually intentional. Lawmakers looked at history, seeing how even really simple algorithms deployed for things like combating fraud had a devastating effect on people's lives. They want these systems too to fall under these rules of the AI Act. This means even if your AI system seems relatively simple, it likely falls under the scope. Now for the critical part for any business leader who must follow these rules. The Act makes a distinction based on your role in the AI system's lifecycle. Let's look at the key players defined by the Act. First of all, we have the providers. These are the organizations that create and develop AI systems. They invent the AI and put the AI on the European market, essentially selling it for use by others. If your business builds AI models or systems and makes them available to others in the EU, you are a provider. Then we have the deployers. These are the organizations or people that actually use the AI for their own purpose or specific goals. This use can be the AI working on data in a computer or being integrated into a physical product. If your business uses AI internally, uses third party AI software, or integrates AI into products you sell, you are a deployer. Next, we have the importers. If you bring products containing AI systems into the European Union from outside, the rules apply to you as an importer. Then we have the distributors. If you circulate products containing AI systems throughout the EU, you have specific rules to follow as a distributor. Crucially, these rules are not mutually exclusive. Your business can simultaneously be both a developer, provider, and a user deployer of an AI. This happens, for instance, when you create your own AI models and use them in practice within your operations. This means that when you use AIs in your organization, you need to figure out which rules you have to respect to that AI. Understanding your role is the first critical step to understanding your obligations. Now, let's dive into what those rules actually are. The Act organizes the rules by categories of AI systems based on their risk level. This is the core mechanism balancing innovation and safety. There are four main categories. The first is prohibited AI practices. As the name suggests, these are AI uses that are so dangerous to society that they are forbidden. The EU basically says, we don't want you to use those anymore. There is a short list of about 8 of these types of systems. If your business is involved in or planning to be involved in any of these specific activities, you must stop. These are forbidden to be used. The second category is high-risk AI systems. This is a larger category. These systems can bring huge benefit to society, but at the same time, they can also harm people in many, many ways. Because the risk is very high here, businesses need to take extra care when they deploy these AIs. Where can you find these systems in business? You can often find them as part of the safety elements of physical products, for example. Think of AI used in cars, in toys, and machineries, or even as standalone AIs that do our daily business tasks or provide specific societal functions. This could include AI used when it comes to using data on employees or in areas like critical infrastructure, credit scoring, or educational access. If your business develops or deploys AI in these high risk areas, you must follow specific rules to make sure you don't harm people. These rules cover things like data quality, technical documentation, human oversight, cybersecurity, and more. Then we have the category of AIs with transparency obligations. This category applies to AI that generates content where it's not obvious that those things are not real. Think of deepfakes, images, text, or video generated by AI. If it's not clear to an average human being that this is not real, but this is AI made, then you should state so upfront. For example, if you create a deepfake, you must state this is a deepfake. If you create text for public release using AI, you might have to say this text was AI generated in some circumstances. If your business creates or uses AI tools to generate content that could deceive or mislead users because it's not obviously artificial, you have a transparency obligation. And finally, we have the general purpose AI. These are systems made with no specific purpose in mind, but they have broad functionality. Think of your large language models, your image generators, etc. The provider makes those AIs, but you, as the end user, the deployer, decide for which purpose you are going to use those. This shifts the balance a bit between provider and deployer on who has to take care of what. The analogy given is a text editor. The provider gives you the tool, but you choose whether to write a legal letter or an illegal one. If your business develops general purpose AI, you have obligations related to the foundational model itself. If you use general purpose AI, your obligations often depend on how you use it. If your use case falls into a high risk category, for example, then the high risk rules apply to your deployment of the general purpose AI. The rules ensure we classify how the provider and the deployer have to use them and have to work with them. Beyond these risk categories, there's an overarching requirement, particularly for providers and deployers, the protection of fundamental rights. As citizens living in the European Union, people have a number of fundamental rights that cannot be violated, not by governments, not by companies, not by other people. There are 50 of them divided into 6 categories: dignity, freedoms, equality, solidarity, citizens' rights, and justice. You will find in there the right to human dignity, the right to non discrimination, the right to privacy, the right to a fair trial, and many more. While some rights may seem further from AI applications, all those 50 fundamental rights have to be taken into account by the providers and deployers of AI so that they don't violate them. For any business developing or deploying AI, ensuring your systems do not violate these numerous fundamental rights is a fundamental compliance requirement. This requires careful consideration during design, development, testing, and deployment. Now, acknowledge that introducing strict rules could risk hampering innovation. The Act also includes mechanisms to support it. One key example is the sandbox mechanism. The AI Act creates a sandbox for you. In this controlled environment, your business can come and take your AI, take your data, take your algorithms, play around with it. This is allowed even if it's not following the rules that strictly initially. It provides a protected space for experimentation and development. The key stipulation is that what happens in the sandbox stays in the sandbox. This is a fantastic opportunity for businesses involved in AI research and development. It allows you to test new solutions responsibly before they are fully compliant and released to the market. So, what should your business be doing now? First of all, you have to identify your roles. Are you a provider, a deployer, an importer, or a distributor? Or perhaps a combination? This determines which part of the Act applies directly to you. Second, inventory your AI systems. What AI are you currently using or developing? Make a comprehensive list. Third, assess risk. For each AI system you use or develop, determine its risk category under the Act. Is it prohibited? High risk? Does it require transparency? Is it general purpose AI being used for a specific purpose? 4. Understand the applicable rules. Based on the risk category and your role, identify the specific rules your business must follow. For high risk systems, this involves detailed compliance requirements. For all providers and deployers, it involves the crucial obligation to protect fundamental rights. Fifth, leverage support mechanisms. If you are innovating, explore the sandbox mechanism as a way to test and refine your AI solutions responsibly. The EU AI Act is a significant piece of legislation. It defines AI broadly, places obligation on key players in the AI lifecycle, categorizes AI systems by risk with corresponding rules, strongly emphasizes the protection of fundamental rights, and supports innovation through tools like sandboxes. Other regions in the world are working on similar acts or legislations. So, figuring this out in the EU puts you ahead of the curve everywhere else. Thank you for joining me. Stay informed, assess your AI landscape, and prepare your business for the era of regulated AI.